Okay, I'm live now. I'm reading the Landlord's Legal Guide, which is a NOLO book. NOLO, about NOLO Press Law for All, is that NOLO Press was started by two legal aid lawyers who were fed up with the fact that the average person couldn't find affordable legal information and advice, convinced that with good, reliable information, Americans could handle routine legal problems without hiring an attorney. They began writing plain English law books for non-lawyers. Now, 25 years later, Nolo Press publishes more than 100 titles. I just read one. I think I am going to be focusing on maybe even starting with chapter 16, problems with tenants, how to resolve legal disputes without a lawyer. Lawyers and legal research is chapter 17. But to go through some of the important need to know information, there's an introduction, screening tenants, your most important decision, how to avoiding illegal discrimination, advertising, renting property that's still occupied, dealing with prospective tenants, checking references, credit history, and more, choosing an applicant. Chapter 2, preparing leases and rental agreements. I like the topic E, how to modify signed rental agreements and leases. This is an interesting question. Which is better, a lease or a rental agreement? Basic rent rules. I see in chapter 3, how much can you charge, rent control, when rent is due, where and how rent is due, late charges and discounts for early payments, return check charges, partial or delayed rent payments, raising the rent, security deposits, what is it, dollar limits on deposits, how much deposit should you charge, last month's rent, interest and accounts on deposits, non-refundable deposits, holding deposits, how to increase deposits, handling deposits when you buy or sell rental property, discrimination, legal reasons for refusing to rent to a tenant, sources of anti-discrimination laws, types of illegal discrimination, valid occupancy limits, managers and discrimination, unlawful discrimination complaints, insurance coverage and discrimination claims, property managers, hiring your own resident manager, how to prepare a property manager agreement, your legal obligations as an employer, management companies, your liability for a manager's acts, notifying tenants of the manager, firing a manager, evicting a manager. And chapter 7, getting the tenant moved in, inspect and photograph the unit, send the tenants a move-in letter, cash rent and security deposit checks, co-tenants, sublets, and assignments. Co-tenants, what to do when a tenant wants to sublet or assign, when a tenant brings a roommate, guests and new occupants you haven't approved, landlord's duty to repair and maintain premises, the implied warranty of habitability, how to meet your legal responsibilities, delegating landlord's responsibilities to tenants, tenants' right to reduce or withhold rent. It's all chapter 9, as well as your options if a tenant reduces, repairs, or deducts or withholds rent. When the tenant sues or moves out, avoiding problems by adopting a good maintenance and repair system, tenant updates and landlord's regular safety and maintenance inspections, landlord's liability for dangerous conditions, differences in state law, landlord's evolving responsibility for safe housing, liability for negligence, your duty towards guests and trespassers, strict liability, liability based on a contract forbidding tenants to make repairs, liability based on failure to keep the premises habitable, liability for reckless or intentional acts, avoiding lawsuits through prevention, using exculpatory clauses to shield yourself from liability, liability and other types of property insurance, landlord's liability for environmental health hazards, asbestos, lead, and radon, landlord's liability for criminal acts and activities, your responsibility for basic security measures, your responsibility to provide enhanced security, how to protect your tenants from criminal acts, protecting tenants from each other, your responsibility for an employee's criminal acts, protecting neighbors from drug-dealing tenants, what you can do to prevent drug lawsuits and seizures, landlord's right of entry and tenant's privacy, general rules of entry, entry in case of emergency, entry with the permission of the tenant, entry to make repairs or inspect the property, entry to show property, entry after the tenant has moved out, what to do when tenants unreasonably deny entry, tenants' remedies if a landlord acts illegally, other types of invasions of property, and ending a tenancy, month-to-month tenancies, fixed-term tenancies, and when a tenant dies. That's all Chapter 14. So the only chapter I haven't outlined yet is Chapter 15, returning security deposits, preparing a move-out letter, inspecting the unit when the tenant leaves, applying the security deposit to the last month's rent, basic rules for returning deposits, deductions for cleaning and repairs, deductions for unpaid rent, preparing an itemized statement of deductions, mailing the security deposit itemization, security deposits from co-tenants, and if a tenant sues you, and if the deposit doesn't cover damage and unpaid rent. There's a lot of tables in the appendix, such as landlord-tenant statutory codes, attachment to Florida leases and rental agreements, state rent rules, state laws on security deposits, states that require interest on deposits, state fair housing agencies, state consumer protection offices, state laws on rent withholding, the repair and deduct remedies, state-led hazard reduction laws, state laws on landlords' access to rental property, and state laws on notice required to terminate a month-to-month tenancy. And then there are tear-out forms such as rental application, consent to background and reference check, tenant preferences, month-to-month residential rental agreement, fixed-term residential lease, amendment to lease or rental agreement, agreement for delayed or partial rent payments, property manager agreement, landlord-tenant checklist, termination of tenancy agreement, consent to assignment of lease, letter to original tenant and new co-tenant, residence maintenance, repair request, time estimate for repair, semi-annual safety and maintenance update, notice of intent to enter dwelling unit, tenant's notice of intent to move out letter for returning entire security deposit itemization with deductions for repairs and cleaning, the same for deductions for repairs, cleaning, and unpaid rent, warning letter for lease or rental agreement violation, disclosure of information on lead-based paint or hazards. You don't really have probably because it's state specific, but they don't really have like the 3 days or quit letter, for example, signs that get posted. I wanted to go directly to the appendix tables, mainly because I saw the state rent rules and wanted to cite California Civil Code section 1942, California, and that's for when rent is due. The notice for raising rent is California Civil Code 827. Definitely have a copy of that. I don't know if that's one that was in the appendix. State laws on security deposit is California Civil Code section 1950.5. Statutory codes, I think generally speaking, is California Civil Code section 1925 through 1954, 1961 through 1962.7, 1995.010 through 1997.27. So those are your statutory codes. And there's this attachment to Florida leases and rental agreements that says Florida statute annotated section 83.493A, upon the vacating of a premises for termination of the lease, the landlord shall have 15 days to return the security deposit together with the interest, if otherwise required, in which to give the tenant written notice by certified mail to the tenant's last known mailing address of his intention to impose a claim on the deposit and the reason of imposing the claim. The notice shall contain a statement substantially the following form. This is a notice of my intention, and actually everything that I just said sounds consistent with at least what I read about Oakland. This is a notice of my intention to impose a claim for damages in the amount of a line upon your security deposit due to a line. It is sent to you as required by Section 83.493 Florida statutes. You are hereby notified that you must object in writing to this deduction from your security deposit within 15 days of the time you receive this notice, or I will be authorized to deduct my claim from security deposit. Your objection will be sent to landlord's address. If the landlord fails to give the required notice within the 15-day period, he forfeits his right to impose a claim upon the security deposit. Unless the tenant objects to the imposition of the landlord's claim in the amount within 15 days after receipt of the landlord's notice of intention to impose a claim, the landlord may then deduct the amount of his claim and shall remit the balance of the deposit to the tenant within 30 days after the date of the notice of intention to impose a claim for damages. C. If either party institutes a action in a court of common jurisdiction to adjudicate his right to the security deposit, the prevailing party is entitled to receive his court costs plus a reasonable attorney fee for his attorney. The court shall advance the case on the calendar. So, I read that because I happen to be leasing a property in Florida right now. I read the state rent rules for different reasons, such as on security deposits, and also generally and when rent is due, and notice for raising rent. Any other states that require interest on deposits? California is not here. Florida is. Pennsylvania is. PA statute annotated Title 68, Section 250.511A, whereas Florida is Florida statute annotated 83.49. And I don't think these agencies are worth speaking on. State consumer protection offices might be, but relevant, the tenants. But landlords can direct their tenants there for maybe assistance or something, like with COVID having happened. I recall doing that. Lead hazard. Okay, rent withholding and rent and deduct liability remedies. So, okay, Green versus Superior Court is a seminal case in California, 10 Cal 3 616 1974, citing California Civil Code 1942, are the citations for state laws that allow tenants to withhold rent or use the repair and deduct remedy for landlord's failure to provide habitable premises. In Florida, you just have a statute on. Oh, okay. The case I cited, Green versus Superior Court, that's the statute on rent withholding, and the statute on repair and deduct was the Civ Code 1942. But Florida has only a citation for rent withholding and doesn't have a citation for repair and deduct. The Florida statute annotated section 8360, like .60, .201, .232. What does Pennsylvania say? They only have a statute on rent withholding. PA statute annotated Title 68, section 250.206. No statute on repair and deduct. Lead hazard reduction laws. Looks like every one of these states has it, except surprisingly Florida. Maybe that's because I don't know why that would be, but we got it in Pennsylvania, I'm sure, with State laws on landlords' access to rental property. Actually, Pennsylvania is not in this list, but I know it applies to Pennsylvania, like lead hazard reduction laws. So this list just must be old. Access to the rental property. Okay, it does kind of elaborate with what applies. So in California, according to the California Civil Code 1954, 24 hours is the amount of notice required for a landlord to enter, and they may deal with an emergency. They may not inspect the premises, but they may make repairs, alterations, or improvements and show property to prospective tenants or purchasers, but they may not enter during a tenant's extended absence. In Florida statutes annotated 8353 West Supplement gives 12 hours advance notice, and they can do everything. Deal with an emergency, inspect the premises, and we're talking in 12 hours, make repairs, alterations, improvements, appear during a tenant's extended absence to show the property. And let's see what Delaware does. Delaware allows everything, but they need 2 days advance notice. Pennsylvania, there's no statute on it, and there's nothing written here. And it's funny because I don't, actually, it's not time to talk about my leases. State laws on notice required to terminate a month-to-month tenancy. Oh, right. So California Civil Code 1946, Florida statute annotated 8357, and PA statute annotated Title 68, Section 250, and 501. So the tear-out forms are next. You see the rental application and all the stuff that I listed before. It's all still, it looks like it's still in the book, which is great. Let's go to the first section that really sparked my interest, which was, I think, modifying a contract that's already, how to modify signed rental agreements and leases. All amendments to your lease or rental agreement should be in writing and signed by both you and the tenant to be legally binding. If you want to change one or more clauses in a month-to-month rental agreement, there is no legal requirement that you get the tenant's consent, although it's always a good idea to do so. You can simply send the tenant a notice of the change. Most states require 30 days advance notice subject to any rent control ordinances. However, if you use a lease, you cannot unilaterally alter the terms of the tenancy. If you use a lease, you cannot unilaterally alter the terms of the tenancy. Chapter 14 discusses more notice requirements to change terms of a rental agreement. Okay, so leases and rental agreements are different, and I don't particularly know why. So here we've got signing a lease or rental agreement. Not sure if it defines these things. At the end of a lease or rental agreement, there's a space to include your signature, street address, phone number, person authorized to receive legal papers like a property manager. There's also a space for 10 signatures if the tenant is a co-signer. You'll need to add a line for the co-signer signature. Be sure that your tenant reviews the lease or assignment before signing and clear about all the terms and any attachments such as rules and regulations before you and the tenant sign the document. So in the preparing leases and rental agreement section, there's some clauses that are discussed. in greater detail. I mean, one of them I'm going to read is payment of court costs and attorney fees in a lawsuit in any action. The language is in any action or legal proceeding to enforce any part of this agreement, the prevailing party shall not or shall recover reasonable attorney fees and court fees. Many landlords assume that if they sue a tenant and win, the court will order the losing tenant to pay the landlord's court costs, filing fees, service of process charges, deposition costs, and so on, and attorney fees. In some states and under certain conditions, this is true. For example, in Arizona, a landlord who wins an eviction suit is eligible to receive costs and fees even if the lease does not have a costs and fees clause in it. But in most states, a court will order the losing tenant to pay the attorney fees only if the written agreement specifically provides for it. If, however, you have an attorney fee clause in your lease, all this changes. If you hire a lawyer to bring a lawsuit and win, the judge will order your tenant to pay your costs and attorney fees. In rare instances, the court will order the loser to pay costs and fees on its own if it finds that the behavior of the losing party was particularly egregious. By law in many states, the attorney fees clause, I feel like it cuts both ways. Waste and nuisance, what are they? State mandated additions to security deposits clause. The only one here is the Florida one. I'm talking about interest on deposit when the security deposits return. Non-refundable fees are illegal in many states. Cleaning and pets, for example. Be clear in the lease or rental agreement. Okay, so which is better, a lease or rental agreement? One of the key decisions you need to make is whether to use a lease or rental agreement. To decide which is better for you, read what follows and carefully evaluate your own situation. 1 is a month-to-month rental agreement, and 2 is a fixed-term lease. Okay, so that explains everything without having to read much more. And I think I'm going to actually call it quits a little bit early. But before I do, I'm just paging through chapter 1, and which entails the rental application. There's illegal discrimination, and I think I might actually read this just to satisfy my own curiosity. Choosing tenants is the most important decision any landlord makes, and to do it well, you need a reliable system. Follow the steps in this chapter to maximize your chances of selecting tenants who will pay their rent on time, keep their units in good condition, and not cause you any legal or practical problems later. Before you advertise your property for rent, make a number of basic decisions, including how much rent to charge, whether to offer a fixed-term lease or a month-to-month tenancy, how many tenants can occupy each rental unit, how big a security deposit to require, and whether you'll allow pets. Making these important decisions should dovetail with writing your lease or rental agreement. Avoid illegal discrimination. Federal and state anti-discrimination laws limit what you can say and do in the tenant selection process. Because the topic of discrimination is so important, we devote a whole chapter to it later in the book, chapter 5, including legal reasons for refusing to rent to a tenant and how to avoid discrimination in your tenant selection process. You should read chapter 5 before you run an ad or interview prospective tenants. For now, keep in mind 3 important points. You are legally free to choose among prospective tenants as long as your decisions are based on legitimate business criteria. You are entitled to reject people with bad credit histories, income that you personally regard as insufficient to pay the rent, or past behavior such as property damage or consistent late payments, and that makes someone a bad risk. A valid occupancy limit that is clearly tied to health or safety or legitimate business needs can also be a legal basis for refusing tenants. It goes without saying that you may legally refuse to rent to someone who can't come up with a security deposit or meet some other condition of the tenancy. Anti-discrimination laws that specifically specify clearly illegal reasons to refuse to rent to a tenant. Federal law prohibits discrimination on the basis of race, religion, national origin, gender, age, familial status, physical and mental disability, including alcoholism and past drug addiction. Many states and cities also prohibit discrimination based on marital status or sexual orientation. Consistency is crucial when dealing with prospective tenants. If you don't treat all tenants more or less equally, for example, if you arbitrarily set tougher standards for renting to a member of a racial minority, you are violating federal laws and opening yourself up to lawsuits. How to advertise rental property. You can advertise rental property in many ways: putting an apartment for rent sign in the front of the building, taking out newspaper ads, posting flyers in the neighborhood bulletin boards, listing with a housing rental or local locator service that provides a centralized listing of rental units for a particular geographical area, buying ads in apartment rental guides or magazines, or posting a notice online on a local electronic bulletin board or specialized news group. Excuse me. What will work best depends on a number of factors, including the characteristics of the particular property, its location, your budget, and whether you are in a hurry to rent. Many landlords find that instead of advertising widely or having to screen many potential clients, my battery is going to cut off soon, so I'm actually going to end it here on page numbers. I just have section 1-3, the top of that page.